This guide will give you some excellent tips on when you should and shouldn't liaise with that expert and where that line is and what is appropriate. A common challenge, I think, in briefing experts is the temptation to try and secure a certain result. Of course, we're long past the days where you had an expert on your side to be a mouthpiece for you. An expert's duty is to assist the court with independent advice. Having said that, of course, a well-briefed expert and consultation with that expert all the way through the process, you're going to have a fairly good sense of where that evidence is going to go, even though, of course, you are unable to shape it. In briefing an expert, it's important to give them enough information to form their opinion, however, not so much that they're overwhelmed. Avoid the temptation to shape the case by only giving them half the side of the picture. What you'll find is if you've done that, once you're in court and you've got that evidence in the box, that will come unstuck very quickly. So avoid the temptation from the beginning, speak with that expert from the beginning, work with them to formulate the questions in order to ensure that their evidence is independent and assists the court. I'd certainly encourage members to get across this topic of law. I'd encourage them to read the Practitioner's Guide to Briefing Experts. With the rise of a litigious society, briefing experts will become more and more important, and even outside litigation. In terms of transactional law, you may engage an expert and you never know where that matter may end up. It may end up in litigation. Certainly there are organisations out there that can help you select, vet and train that expert to give evidence to the court in a clear and concise way.